Hello and good evening, everyone. Welcome to this evening's webinar on retirement and the impact on benefits. Now I'd like to introduce Debra Schuster.
So let's talk about retirement and its impact on your child's disability benefits. What do we talk about when we're talking about normal retirement age? Believe it or not, most people think the normal retirement age is 65. For some professions, it's 70. Well, Social Security has specific age brackets for retirement when someone will be able to collect certain amounts of Social Security retirement benefits based on their year of birth. So from 1943 to 1954, it's 66. And as you can see in this chart, it progresses from there. From 1960 and later, it is actually age 67. So it is a fallacy when people think, oh, my natural retirement age, normal retirement age under Social Security is 65, because it's not. So what do you get when you retire? A gold watch, a straw hat and Hawaiian shirt, a retirement party. It depends. Not those type of depends, hopefully. If you retire at your normal retirement age, which was listed on the previous slide, you will receive what Social Security calls your primary insurance amount, or your PIA, which is your monthly Social Security benefit. And we will talk at much greater length at what that amount is. So if you create an online account with SSA.gov, it will illustrate your Social Security payments at age 62, which is the youngest age at which someone can retire and collect Social Security if they are not disabled. Your normal retirement age, again, based on the previous slide, and at age 70, which is the age at which someone receives their maximum Social Security benefit. So, like so many other governmental agencies, Social Security is a melange of alphabet soup. Lots and lots of abbreviations. So, some of the principal ones that we'll be talking about tonight. NH refers to the number holder. That is the Social Security number that is actually on your Social Security card. So people can receive benefits under someone else's number. So that's why NH is actually an important abbreviation. Spousal benefits, disabled child benefits can be actually under someone else's Social Security benefit record. NRA, as we have already talked about, is that normal retirement age. FRA is the full retirement age, age 70, at which an individual maxes out at the maximum amount of Social Security benefit that you can receive. RIA refers to retirement insurance benefits, and that's actually the amount of benefit that someone receives from the Social Security Administration when they retire. PIA is the primary insurance amount, which is the monthly Social Security benefit amount that they will receive when they retire at their normal retirement age, not age 62, which is the earliest age, and not age 70, which is full retirement. DIB refers to the disability insurance benefit. There are hundreds of more abbreviations, but these are the primary abbreviations that we'll be talking about tonight when we talk about retirement and its effect on child disability benefits. So how is the Social Security benefit determined? It is determined using what's called the averaged index monthly earnings, and that is a summary of someone's work history over a 35-year period. I don't know how they came up with a 35-year period, but that is presumably what the average individual in the United States works that amount of years. So earnings are adjusted based on inflation, because every year the Social Security Administration has a cost of living adjustment, usually, except during periods of severe economic downturn. 2008, for a number of years following 2008, there was no COLA Social Security increase, and it's usually around 2 or 3%. So, and these change standard of living during a person's working lifetime. And the years with your highest earnings are used to calculate what your Social Security benefit are. So if there's some years that you worked part-time or worked intermittently during a year, or didn't work at all, raised a family, raised children, weren't able to work, they use the highest amount earned during your period of work. Now, it is important to know that you have to have worked during the most recent 5-year period, or you might not qualify for Social Security retirement. But we'll talk about that a little bit later also. So, when does someone first become eligible to retire? Age 62, again, is the earliest retirement age. As of this year, age 66 is the normal retirement age. And again, that can vary, obviously, based on your birth year. Age 70 is when you receive the maximum benefit. So, for example, the maximum Social Security retirement benefit if someone retires at age 70 in this year is $3,895. If somebody retires at age 66 and 2 months, which is the normal retirement age actually in 2021, the maximum Social Security retirement benefit is $3,148. And if someone retires at age 62 this year, their benefit will be $2,324. So you see that over that 8-year span from age 62 to 70, there is a fairly significant variation in the amount of Social Security someone can collect. And deciding when one retires really takes into a lot of factors. So this is not necessarily as easy a decision as it may seem, and can affect a lot of issues. So your benefit is 25% less if you retire at age 62. By retiring at age 70, your benefit is 59.6% more than when you retire at age 62, $130.91 per month. So if a person retires mid-year, the annual earnings limit may have already been reached. So there's a special retirement year rule that allows someone to receive their first full Social Security benefit per month for any whole month of retirement, regardless of their yearly earnings, if they retire in their normal retirement, at their normal retirement age. So, for example, Tom retires at age 62 on 9/20 of year 2020, and it earned $45,000 through September. He takes a part-time job in October and earns $500 per month. So long as he doesn't earn more than $1,310 per month, that number is very significant because that is what Social Security deems significant gainful employment. That is the amount. If someone exceeds that amount, they cannot collect Social Security retirement unless they're of normal retirement age. So Thomas retired early at age 62, but he'll be able to receive his full monthly retirement benefit for the remainder of that year, so long as he doesn't earn more than $1310 for the remainder of the year each month. But again, if he retires at age 62, he won't get his full retirement amount. He'll only receive the amount that he'd receive at age 62. People that are self-employed, if you work more than 45 hours per month, you are not considered retired by the Social Security Administration. If you work less than 15 hours a month, you are considered retired. And of course, this is based on those retirement ages that we just discussed. If you work between 15 and 45 hours per month and you are not retired if the job requires significant skill or you're managing a sizable business. And these are all, again, definitions under the Social Security Administration. If you haven't contributed to Social Security for the past 5 years, you may lose your eligibility also for Social Security disability. So self-employment can really be a conundrum because many people who are self-employed choose not to pay themselves and instead reinvest in the business or may pay for inventory or pay for employees or employee benefits and forego paying themselves. And the problem with that is if you do not pay yourself a paycheck and pay into the Social Security retirement system, you will be affecting your ability to potentially collect both Social Security disability and affect your Social Security retirement. So those are really significant considerations if you are self-employed. Even if you retire before your normal retirement age, you will not be eligible for Medicare until age 65 unless you're determined to be disabled by the Social Security Administration. That's a whole nother category of consideration. So how does your retirement affect your child's benefits? If you have a child that was disabled before age 22, he or she can receive Social Security disability benefits when you retire, and that is called the Disabled Adult Child Benefit, or DAC. This is a category of benefits that is available if the child is 18 or older and was disabled before age 22. The child meets the definition of disabled, and the child is not married or is married to another person who's receiving Social Security disability, and the child's parent is receiving either Social Security disability benefits, Social Security retirement benefits, or is deceased. So all of these categories must be met for a child to receive disabled adult child benefits. So how does the Social Security Administration define disabled for a child? That is when a child has a medically determinable physical or mental impairment or both. And that impairment results in marked and severe functional limitations that are expected to last or have lasted a year or more or will result in death. So what is the amount of this disabled child benefit? So when the adult child's parent retires, the child is eligible for 50% of a parent's Social Security retirement benefit. So if a parent retires and his or her Social Security retirement benefit is $2,000 a month, the disabled adult child benefit for the disabled adult child will be $1,000 per month. And this does not reduce the parent's benefit. This is really a tremendous benefit. When the disabled adult child's parent dies, the child is eligible for 75% of the parent's Social Security retirement benefit. So when you retire, it really matters. If you retire at age 62, the DAC, the Disabled Adult Child Benefit your child could receive would be lower than if you wait until your normal retirement age or your full retirement age at age 70. So again, further explanation of what does disabled mean to receive disabled adult child benefits. The applicant has a disability that lasts 12 months, is expected to last at least a year or result in death. And as a result of the disability, they cannot perform this key concept, substantial gainful activity. You will see this throughout the Social Security Administration Program Operating Manual, the POMS, which is kind of the Bible of Social Security law. And the SGA is an amount that is set by the Social Security Administration every year. And for 2021, it is $1,310. For blind individuals, it is $2,190. So it varies. Medicaid, also has blind pension and amounts that people can receive. So these amounts can vary. Social Security publishes a list of medical conditions and the criteria to qualify for disability. If a condition is actually not on the list of disabling conditions, the Social Security may nonetheless consider a condition medically equal to a listed condition, which could also qualify. So again, if someone is in doubt, it does not hurt to apply. Unfortunately, people may have to apply more than once to actually have their application approved for disability or for a disabled child. So how does work affect the disabled adult child benefit? To qualify for the disabled adult child benefit, a child cannot have engaged in substantial gainful activity after the onset of his or her disability prior to initially being eligible for the DAC benefit. So let's give an example. Jean was disabled before age 22, but she could work full-time and incur substantial gainful activity, whatever that amount was in those years she was able to work, from ages 25 to 27. She had to stop working due to her disability and reapply for Social Security. When Jean's father retires when she turns 32, she will not be eligible for the disabled adult child benefit because she had been able to engage in substantial gainful activity before her father retired. So these time frames really matter. So even though she was disabled before age 22, because she was able to engage in what Social Security considered substantial gainful activity before her father retired, before she could claim that disabled adult child benefit, she was no longer eligible for it. So, is work prohibited? If a disabled adult child is receiving that DAC benefit and would like to try to work, Social Security has a trial work period of 9 months, during which time that disabled adult child will remain eligible for the full DAC benefit and can earn the significant gainful activity amount for that year each month for those 9 months. So let's use Jean as an example again. Jean has no substantial gainful activity before her father retires when she's age 32. When her father retires, she's eligible for the DAC benefit of $1,000 because presumably her father received a retirement benefit of $2,000. At age 35, Jean is able to work and earns $2,000 a month for 2 years. She'll lose her DAC benefit after that 9-month trial work period, but if she has to stop working due to her disability, she can again qualify for DAC for up to 7 years of work, even though she had more than her SGA because her employment occurred before becoming eligible. So, does marriage affect the disabled adult child benefit? If a DAC recipient marries a person that is receiving Social Security benefits, eligibility is maintained. But if they marry a person who's not receiving Social Security benefits, the disabled adult child will lose their DAC benefit because of what's called deeming. When someone is living with either a parent and they're under age 18, in certain circumstances, which we'll talk about, parents' income can be deemed to the child and therefore affect their eligibility for benefits under age 18. Over 18, if they're living in the household with someone other than their parents that no longer has a support obligation for them, and that person is not receiving Social Security but they're working, then that person's income will be attributed to them. And if they're married to someone, certainly, who is working, that married individual's income and assets will be attributed to the disabled adult. If an adult child ceases to meet the requirements for DAC, they can retroactively approve DAC benefits from the date of application to the date of benefit termination. So, let's talk about Jean again. Jean's mother retires when Jean is age 24 and applies for DAC for Jean. But Jean marries Tom when she turns 23. So before the application for DAC was made. and Tom does not receive Social Security benefits. So Jean won't receive DAC benefits from 24 on, but she can be retroactively approved from 18 to 23 because she was disabled before age 22. Let's go through some more examples using Jean. So Jean was permanently disabled at age 15. When she turned 18, her parents applied for SSI for her, Supplemental Security Income, which we'll talk about a little bit later. And she was approved for the maximum benefit, which in 2021 is $794 a month. When Jean was 30, her father retired and received Social Security retirement benefits in the amount of $2,000. Her parents applied for DAC for her. She meets all the requirements because she was disabled before age 22 and received that $1,000 DAC benefit and no longer receives SSI. When Jean is 40, her father dies, and her DAC will increase to 75% of her father's benefit, which gives Jean $1,500 a month, which will continue for her lifetime unless she's able to engage in substantial gainful activity for more than 7 years. So this kind of rounds out the whole concept of the disabled adult child benefit based on a parent's retirement and then death, and what that benefit is for the disabled adult child.
Now, what if there are two children involved in the process of retirement? Like if there were two Jeans.
Right. There should not be a problem. They can both, do you mean if they're both disabled before age 22, they can both receive disabled adult child benefits. There is, we'll talk about in a minute, a maximum family amount of benefit that can be received from Social Security. But two children can still receive disabled adult child benefits in the same family. So the next slide is the caregiver spouse benefit. So this is that answer to the question that was asked about how much a caregiver or a spouse can receive. A spouse of a retiree may also qualify for Social Security benefits if the spouse is caring for a special needs child at home, even if the spouse is not yet at her normal retirement age or age 62, and that would be 50%. So the father retires and receives Social Security retirement benefits, or mother. Because the child has been disabled since birth, the child can receive disabled adult child benefits. The retiree's wife who cares for the child at home can receive the spousal Social Security benefit, 1/2 of the primary insurance amount, even though she's only 58. So that is an example of a spouse receiving 50% of the retiree's benefit for caring for a disabled child at home. And this is the answer to the question about, is there a limit to how much a family can receive from Social Security? So the maximum benefit a family can receive when a retiree receives Social Security retirement benefits, a spouse receives spousal caregiver benefits, and a child with disability receives DAC, is called the maximum family benefit, which is between 150 and 180% of a retiree's full retirement benefit at their normal retirement age. So, walking through this, the maximum family benefit cannot be higher than 85% of the disabled family member's average index monthly earnings. And it can't fall below the disabled family member's primary insurance amount. So the best way to think about it is the maximum family benefit is the smaller of 85% of the disabled family member's average index monthly earnings, or 150% of the disabled family member's primary insurance amount. And the best way to do this is to go on the Social Security SSA.gov website and look at what the retiree's benefit will be at those various age break points, 62, their normal retirement age, and age 70. And one can calculate roughly what these benefits are. Are there other benefits your child may receive when you retire? And that is absolutely true. And this is Medicare. This is one of the absolutely best features of the disabled adult child benefit. 24 months after becoming eligible for the disabled adult child benefit, that child is eligible for Medicare. There is no waiting period if the child has chronic renal disease and needs a kidney transplant or maintenance dialysis or has ALS. And this is actually true for any adult. If they have end-stage renal disease or ALS, they can get their Medicare benefit immediately. There's no waiting period. Because normally when someone is approved and adjudicated as disabled through the application process with Social Security, they have to wait 24 months before they're eligible for Medicare. And this is where many people, if they don't have other health insurance, have to apply for Medicaid as a bridge. If they don't qualify for either COBRA through employer benefits or for marketplace benefits through the health exchange. So if an application for DAC is made when a child turns 18 and they're eligible in all the other ways, they'll be eligible for Medicare at age 20. That's 24 months after they've been determined to be eligible. So somebody could apply for disabled adult child benefits or for Social Security disability and be rejected the first time, appeal and be approved the second time, and that application would be retroactively approved back to the date of first application. So they may actually immediately become eligible for Medicare if 24 months have passed from that date of first application. So what does Medicare cost in 2021? And this is true for someone who is retired at age 65 and applies for Medicare, or who receives Medicare after retiring from an employer situation and having been covered from employer coverage, so they may actually delay their Medicare benefit until they retire from employment and are no longer covered under an employer group policy or a retiree policy. So for all of those individuals, Part A premium has no cost if the retiree, again, has 40 quarters of coverage and qualifies for full Medicare benefits. There are ways to purchase Medicare, but we're not going to get into this during this presentation. But there are definitely ways you can basically buy into the system if you have a certain number of quarters of coverage, but not quite 40. The inpatient hospital coverage, which is Medicare Part A, the first 60 days are covered through the inpatient deductible. And for 2021, that's $1,484 per benefit period, per spell of illness. So each consecutive 60-day break from an inpatient hospital or nursing home stay is called a spell of illness, which will be covered by Medicare. There's only one deductible that's due for an entire year, and that is that $1,484 for 2021. There is a coinsurance amount per day for days 61 to 90 of inpatient hospitalization, and that's $371 a day. For periods of inpatient hospitalization of 91 days or more, these are called lifetime reserve days. And there's only a bank of up to 60 days for someone's lifetime. And the coinsurance amount for your lifetime reserve days is $742 a day. So this can really become extremely costly. So once someone first becomes eligible for Medicare, whether it be through a disabled adult child benefit, through becoming eligible for Medicare because of a disability determination or retirement, they should immediately look into a Medicare supplement, because a Medicare supplemental policy is a policy that is not provided by Medicare. They're provided by private insurance companies, and they all have standard pricing and have to have similar benefits, and their benefit categories A through F, but all of them cover the deductibles and coinsurance that arise under Medicare. and many of them cover other enhanced benefits. The richest policy, and I don't know what the cost of it is, but it also can cover things like travel benefits. So if somebody travels abroad, it can cover reimbursement for travel costs back to the United States, so someone's Medicare can reimburse for those coverages. But that is a really high benefit policy. But if, as soon as someone becomes eligible for Medicare, they should look into a Medicare supplemental policy, because when someone first becomes eligible for Medicare, they are eligible with no underwriting criteria for a Medicare supplement, or what's called a Medigap policy, because of this gap in coverage, these deductibles and coinsurance amounts that they must pay. That is an invaluable policy. So the Part B premium, Part B Medicare covers covers physician services, laboratory diagnostic services, and outpatient services. And so that premium is deducted from one's Social Security payment. And it is $148.50 per month in 2021. And it's usually deducted from a person's Social Security benefit payment unless for some reason their Social Security is suspended. So for example, if someone needs a guardian and is determined to need someone to handle their finances, they will need a representative payee, or another person that applies to Social Security because someone has been determined to not be able to handle their own finances. That's either through a court proceeding, or if someone becomes incapacitated, a parent or another individual can apply to become a representative payee. They have to go to Social Security, go through an application process, be determined to be appropriate as someone to handle someone else's finances. And for that period until a representative payee is appointed, someone's Social Security payments may be suspended, and their monthly Part B premium may be suspended also. So someone may have to actually physically write a check instead of having it be deducted from their payment. The Part B deductible is $203 per year. And again, this changes every year. If you go to ssa.gov, you can find out what the payment is from 2020, and around December of every year, that's when Social Security publishes the upcoming rates for all of the Medicare parts. So after the payment of the annual Part B deductible, Medicare pays 80% of covered services, and that's reasonable and medically necessary services that Medicare determines a person needs. So it's not just any service somebody wants, but it's those services that Medicare determines are medically necessary and appropriate services. The coinsurance amount is the basically patient amount that the individual pays, and that's 20% of Medicare, of the Medicare approved fee. So for all sorts of Medicare services, medical services that Medicare approves, under Part B, when you go to the doctor, there's a copayment that people have to pay under Parts A and B. We're not going to talk about the full scope of Medicare, but there's also a Medicare Part C, which is a Medicare HMO. And under Medicare Part C, which replaces Medicare Parts A and B, there is no coinsurance amount that's due, because it's a wraparound program and there's usually no amount that's due. But in Medicare Part A and B, you can go to any physician that accepts Medicare, whereas if you apply for Medicare Part C, it's an HMO product. So you have to be in a specific geographic location, and you have to go to a provider that is within that Medicare Part C HMO network. And not all physicians accept Medicare Part C, even if they do participate in Medicare Parts A and B. Then, again, alphabet soup, there's Medicare Part D, which is prescription drug coverage. And This is also a benefit that many people may want to access as soon as they become eligible for Medicare. There are, again, private plans which provide these prescription drug coverages, and each of them has a different formulary, which is the list of drugs that they will pay for. There's a monthly premium, and drug payment co-payments vary by plan, the plan that's chosen. So anybody that is on Medicare that has prescription drugs has likely gone through the process of choosing a Part D prescription drug plan. And they can vary widely. They can have no monthly premium and a higher per drug copayment cost, or they can have a lower, or they can have some monthly premium and have a lower drug copayment cost. Also, you have to make sure that if you're applying for Part D, that prescription drugs that you're taking are actually covered by the plan you choose. If you're someone that spends part-time in Missouri and then goes to Florida or Arizona or another warmer climate during the winter, you need to make sure that your Medicare prescription drug plan will cover you where you are. Most Medicare prescription drug plans do cover people if they move to different places for a portion of the year, if you're a snowbird and you go somewhere to a warmer climate, or if you go to a colder climate. Because most prescription drug plans, even though they are through AARP or SilverScript or another private insurance company, the benefit is provided through a pharmacy such as Walgreens or CVS that has nationwide coverage. So you just have to make sure all of these variables are accounted for before you choose these various plans. So in 2007, the Centers for Medicare and Medicaid, CMS, which is the federal governmental agency that administers the Medicare and Medicaid program, instituted something called the income-related monthly adjustment amount that applies an increase to Medicare Part B, those physician and outpatient procedures that Medicare covers, and the Medicare prescription drug premiums that are based on the tax return income that is reported 2 years prior. So for 2021, Medicare will look at someone's tax return that was filed in 2019. Now, because of COVID, this is suspended. So they're looking at 2018. I don't know how long this is going to go on, but there's an indefinite suspension until COVID is deemed to be eradicated, hopefully. But under this income-related monthly adjustment amount, Medicare looks at your income from the tax return that you filed 2 years ago and applies it to your current premium for Part B and Part D. So, if your yearly income in 2019, and this actually should be 2018, this will be reflected in what you pay in 2021. If you file an individual tax return and you received income of $88,000 or less, you filed a joint tax return and you, as a joint married couple, received $176,000 of income or less, or you're married and file separate tax returns and again receive $88,000 or less, your Medicare Part B premium will be that normal $148.50. Then there are income brackets. So if you're an individual and you receive between $88,000 and up to $111,000 a year, and then you can read if you're filing jointly or filed married and file separate tax returns, your Medicare Part B premium will increase to $207.90 from $111,000 to $138,000, or if you file jointly, $222,000 to $276,000, your Medicare Part B premium will be $297. $297 per month, and so forth. So you can see that this may happen in one tax return year where you might have received an income bump due to a number of factors, which will only occur in that year. So in the following year, if you then go back down to the amounts that Medicare considers to be applicable for that base Medicare Part B premium, there is an appeal process. So if it is a one-time occurrence, if there is a change in status such as married, widowed, retirement, those are all changes in status that Medicare will recognize and will then reduce your Part B and Part D premium. So for Medicare Part D, again, you can see there is a corresponding increase in both Medicare Parts B and Part D due to this increase in income. So for $88,000 or less, it's only whatever the plan premium is for the Medicare Part D, the prescription drug plan that you choose. If you receive above $88,000 per year, or up to $111,000 per year, and this amount, if you file jointly, it's going to be an additional $12.30 plus the plan premium for the prescription drug plan you choose, and so on. So you can see how Medicare Part D premiums and Part B premiums are affected by these various income brackets. So an disabled adult child benefit may also be affected by the parent's income-related increase. So often this income-related increase results from the required minimum distributions that arise from IRAs that begin at age 72, which is the age due to the Secure Act, which is a whole other tax code change that occurred last year, or if somebody attained age 70 and a half prior to 2020. So a parent may want to consider using IRA funds to purchase life or long-term care insurance hybrid products to reduce or eliminate this income-related bump in their Medicare Part B and Part D premiums. So they may accomplish two things in one fell swoop: reducing that income-related increase, and also by using IRA funds, and also being able to acquire life insurance or long-term care insurance. So how can a disabled child afford Medicare coverage? A disabled adult child is automatically eligible for a 6-month enrollment period when first eligible for disabled adult child benefits. So you should absolutely look into a Medigap or Medicare supplemental policy. They're the same. That's the same vernacular or term for this Medicare supplemental policy when someone's first eligible, if it's financially feasible. A basic Medicare supplemental policy that covers the premiums of Part B and the co-payments is something around $170 a month. So that might be something that SSI could be used for if there are not other costs that someone is using them for. After that 6-month open enrollment period, you may not be eligible due to underwriting. So it really is important to get it as soon as possible. So Medicaid in Missouri is known as Mo Health Net, which I'm sure many of you know, if not all of you. And many disabled adults apply for Medicaid to obtain health insurance coverage until that Medicare kicks in during that 24-month period, after they've been approved for Social Security disability, but before Medicare begins. Medicaid can cover Medicare premiums, co-payments, and deductibles if the individual applies for the Medicaid Qualified Medicare beneficiary program. So some people don't use Medicaid for the health insurance itself, but they use it for Medicare premiums and co-payments. And those are individuals who qualify for the low income. There's the SLMD program, or the qualified Medicare QMB Medicare program, and they pay different levels of Medicare premiums. So let's talk about Medicaid. So Medicaid provides health insurance coverage for children with disabilities from birth throughout their lives if it is needed. And some people qualify for the Affordable Care Act and marketplace policies instead of Medicaid if that scope of coverage is sufficient for someone's needs. Medicaid, though, is income and asset-based. Those are called needs-based programs. But there are certain programs that waive these requirements. So, traditionally, Medicaid for children applies pretty stringent income and asset thresholds that count the income and assets of parents for a child that's applying for Medicaid. For non-disabled children, the Childhood Health Insurance Program, or CHIP, is the most common benefit. But because families with disabled children often require extensive medical services, including in-home services, there are Medicaid programs that waive this criteria. So the Missouri Children with Developmental Disabilities Waiver, the Sarah Lopez Waiver Program, provides home and community-based services to children with developmental disabilities that would otherwise qualify for institutional care. There's also a home and community-based program for individuals that are older, over the age of 63, that don't want to receive skilled services in a skilled institution, but this is on the other end of the age spectrum. And the purpose of this program is to allow children with developmental disabilities to remain at home, receive the services they need, and it waives the rules that ordinarily apply or deem parental income and resources to that disabled child. So the eligibility requirements, and we're just going to skim the surface. We could spend an entire hour and a half on all of these waiver programs. You must be under age 18 and live or are dependent on your parents. And you have to be determined by the Department of Mental Health to need either ICF or institutional level care and be authorized by the department to receive that Sarah Lopez waiver services through medical or psychological assessment by the Department of Mental Health. And that the child's income is below or at the home and community-based maximum, which actually for 2021 is at $1,380 and have assets below $999 and are not otherwise eligible for Missouri Health Net without spend out. So the Sarah Lopez waiver permits the state to view only the child's income when making an eligibility determination. And very often, children don't have any income. So this is not an issue. And so some of the services that are provided through the Sarah Lopez waiver are behavioral therapy, crisis intervention, accessibility adaptations for the home, in and out of home respite care, support broker services, community specialists, habilitation programs, personal assistance, personal specialized medical equipment and supplies and transportation. So it really tries to provide a more holistic wraparound program than institutionalized care. You must be a U.S. citizen or a resident alien to qualify for this, and a Missouri resident for the Sarah Lopez waiver with the intent to remain. Now, every state has its own waiver programs, which vary widely by state, because Medicaid is a creature of both federal and state participation. As we just saw, Missouri, by voter approval, approved Medicaid expansion, but the Missouri legislature is not going to fund appropriations for it. Illinois has a very different Medicaid program, so it really depends on where someone lives to determine what is best for one's Medicaid needs if you're going to apply for Medicaid. And there are often limited waivers available, and there's often a wait list. So, medical assistance for disabled children. And these are more traditional Medicaid benefits than the waiver programs. And there's no criteria that a child requires institutional level care. Parental income and resources are deemed to the child if the child is living with the parent except for retirement accounts. Those are not counted. IRAs, 401ks, 403bs, and pension plans are not counted. The income of siblings or step-parents living in the home are excluded. And parental income and resources are not counted if the parents are receiving Medicaid themselves in a non-spend down category. For spend down, this is available when parents or the child's income is above $732. And what spend down is that if someone is receiving income that's above that level, they have to incur medical expenses and either submit receipts to Medicaid or pay a certain amount above that $732 to Medicaid in order to receive Medicaid benefits. That's what Medicaid spend down is. So these are some of the thresholds for family incomes when looking at medical assistance or Medicaid for insurance, for health insurance. And these are medical expenses that are not reimbursed or paid by a third party of both the disabled child and the child's natural adoptive parents that are used to calculate spend down. So for a household of one, the maximum income level is $17,131, and you can see as the household increases, so does the maximum income that is allowed per year. So when a disabled child attains 18, they are considered an adult in Missouri for a whole host of things. So for receiving information, such as medical information, making medical decisions for a disabled child who's over 18, that child is an adult and the parent can no longer receive information. So if you have a child who doesn't have the ability to create durable powers of attorney that would allow a parent to step in when the child needs someone to make medical decisions or sign a release for medical information, that parent may decide to apply for guardianship. A parent's income and resources are not deemed available or not counted towards a child's eligibility for Medicaid, even if the child is living with the parent, because once a child is 18, they're an adult, and a parent no longer has a legal support obligation for that adult child. So eligibility for Medicaid is based only on that child's income and assets. And so again, this is used to bridge health insurance until Medicare benefits are approved, under DAC, for example. So employer-sponsored health insurance. Under the Affordable Care Act, most employer plans are required to cover children to age 26, but some plans do cover children who are adult disabled child for the duration of employment. You would have to check with your employer-sponsored policy. Retiree health plans also may cover an adult disabled child. Most retiree plans, however, require that a Medicare application be made, and if not, you'll need to weigh the cost-benefit of coverage of the disabled adult child under the retiree plan versus the disabled adult child because of that 24-month Medicare coverage delay. So, SSI. We're talking about supplemental security income, that question about what is the difference between SSI and SSD. So, again, a child is defined as a person under age 18 who is under age 22 and regularly attending school. So to be eligible for SSI, a child must either be blind or disabled, as determined by the Social Security Administration. A child may be eligible for SSI disability benefits until attaining age 18, and thereafter disability is determined as it is for an adult. So supplemental security income is what is available for a child or an adult who does not have 40 quarters of work coverage or who is not paid into the Social Security retirement system for 10 years. That's what 40 quarters are. So SSI supplements income for people who do not otherwise qualify for Social Security retirement or for Social Security disability, or SSDI, also known as SSD. So for children, supplemental security may take 3 to 5 months for the state agency to determine eligibility based on disability. But for certain conditions, SSI is paid immediately for up to 6 months while eligibility is being determined for total blindness, total deafness, cerebral palsy, Down syndrome, severe intellectual disability for children that are age 4 or older, symptomatic HIV infection or birth weight below 2 pounds or 10 ounces, or failure to thrive above age 3. So once SSI is determined based on disability, there will not be a payback requirement if a child was deemed during that 6 month period to not be eligible. They will not seek repayment of that benefit. So again, disability for a child is defined as a medically determinable physical or mental impairment that results in marked and severe functional impairment and can be expected to last for a continuous period of at least a year or result in death. For 18 years, we've already talked about this, that individuals become an adult. So additional ways to financially protect a disabled child are through certain other accounts and financial mechanisms. So ABLE accounts, supplemental needs trusts, the purchase of disability insurance through an employer, or this purchase of hybrid or long-term care insurance. So in Missouri, ABLE accounts are a wonderful feature that is often an adjunct to a special needs trust, which I'll talk about in a minute. And they are found online at moable.com. And this enables a parent, a grandparent, or anyone to invest $15,000 per year, or whatever is the then current maximum gift tax amount that the IRS allows to be gifted to an individual, tax-free, into an ABLE account for a disabled child. It is not countable by SSI or Medicaid, and it can be used for a multitude of qualified medical expenses that are listed on this moable website. This is a tremendous website that tells you exactly how to open a moable account, how much can be invested, what expenses can be used by the money in the account, how to access the account, and it also has a card, or a TrueLink card, which is a debit card attached to the account that allows the use of that card to purchase qualified expenses. So it's really a tremendous account. But again, it's for a child that is considered, that has been disabled before age 22. A wonderful thing about it is it can be funded with up to $100,000 of total account value. You have $15,000 per year before SSI will count it. But SSI benefits will not be terminated. They'll only be suspended until that account value goes below that $100,000. So each year, $15,000 or whatever that maximum gift tax amount can be invested into the account. If more than $15,000 is invested, that amount is taxable. But up to $100,000 in total account value can be invested. And so for many people, this is really a good option instead of a special needs trust, because you don't have to go to the expense of a special needs trust or other types of pooled special needs trusts, which we don't have time to talk about. But an ABLE account is really a wonderful adjunct. It's very similar to a 529 account, but it is for a disabled child. And it can be used to pay rent and food in the month in which the money is withdrawn, and SSI will not reduce the SSI payment, which is absolutely a wonderful thing. There are three types of special needs trusts. Generally, there's a first party special needs trust, which is first party because it is used with the assets of the disabled individual. So through inheritance that is left directly to a disabled individual, through lottery or a lawsuit judgment or settlement that is received by a disabled individual, such as a personal injury or a malpractice settlement or judgment. Those are all assets that are in the disabled individual's name, and a special needs trust can be created. Now, I have a client who received a personal injury award in the millions of dollars, and she decided she did not want to create a special needs trust, even though she eventually is going to need Medicare. And there's a whole nother category of Medicaid issues that arise if you receive a personal injury settlement. But if we're talking about special needs trusts, these are specifically and usually for disabled children or disabled adults before age 65 for a first party special needs trust. And these trusts can be established by the parent, grandparent, guardian, court, or a disabled individual themselves since 2018, because the law changed and this slide wasn't changed. A third party special needs trust is established by anyone who wants to leave an inheritance to a disabled individual. So whenever I'm doing estate planning for parents, grandparents, or anyone, I put in third party special needs trust language, because you never know if a beneficiary that you are leaving money to may become disabled. So there's no reason not to have special needs trust language in someone's estate plan, just as a form, frankly, of insurance, to make sure that someone's benefits are not jeopardized if they need Medicaid or SSI or HUD benefits at some point in the future under a third party or a regular trust that someone may create for their own assets, and they're inadvertently leaving an inheritance to someone who becomes disabled. A sole benefit special needs trust is a very unique and actually rare type of special needs trust. It's established by a parent or other family member who they themselves needs to apply for Medicaid nursing home benefits, and creates it for usually a disabled adult child. So it enables both individuals to qualify for Medicaid. So a parent or grandparent can create this sole benefit special needs trust, and in that way, if they have excess assets, if they have more than $5,000, which is the limit if they're going to go into a nursing home and apply for Medicaid, they can fund a special needs trust for an adult disabled child. And that adult disabled child will then be able to qualify for Medicaid if they need to apply for Medicaid, and still have that inheritance, that money available that the trustee can use for their benefit based on whatever their benefit program eligibility is. So a special needs trust generally enables someone to have an inheritance or lump sum maintained for them, used by the trustee for their benefit, but also have that disabled person qualify for public benefits, Medicaid, SSI. If someone is receiving disabled adult child benefits, and so they're receiving Social Security disability benefits and Medicare, They can still have a special needs trust, but they would not need a first party special needs trust, because a first party special needs trust requires that Medicaid payback. If they're receiving Medicaid benefits and it is their own money through inheritance they've received or through a personal injury or other type of lawsuit or settlement, if that money in that first party special needs trust is not completely depleted by the time they die and they've received Medicaid benefits, Medicaid would seek to be repaid with those benefits, same as an ABLE account. A third party special needs trust does not have a Medicaid payback requirement. We talked about the special needs trust. It's often called a D4A trust. A D4A, a first party special needs trust, has to be created and funded when someone's under age 65. So if we have an individual who is disabled but has reached age 65 or older, they cannot have a first party special needs trust created for them. If they have money that comes into their name, you're going to have to use that money or be on spend down. So for a self-settled special needs trust or a first party special needs trust, the individual has to be disabled according to the then current Social Security definition. And it has to be for the sole benefit of the special needs beneficiary. So if the special needs trust owns a home, which it can, and family members live in that home with the disabled individual, they have to pay essentially rent to the special needs trust because they have to pay their pro rata share. Special needs trust assets cannot be used for the benefit of anyone other than the disabled individual if it is funded with that individual's money. It has to be irrevocable, meaning it cannot be dissolved. Because again, if the money in that trust is available to the disabled person, public benefit programs that count income and assets would then consider that money available to that person, that they'd have to use that before they could become eligible again. The beneficiary cannot be the trustee. They can't dictate how the funds are dispersed or expended. So the trustee has to really calibrate distributions to the beneficiary on the basis of what type of benefit is received. So if the person receives SSI, they really should not distribute benefits to the individual that exceed the amount of income that the person is allowed to receive, or that is for shelter or food, because SSI is intended to be used for shelter and food. And again, there is that requirement of the Medicaid payback. If an individual receives Medicaid from the self-settled or first-party trust, Medicaid can seek to be repaid if there are benefits after that person dies. The third-party special needs trust is really used for inheritance. There's no Medicaid payback requirement. But again, if the disabled individual is receiving SSI, it shouldn't be used for housing or food because it could jeopardize their receipt of benefits. So if someone is receiving benefits and receives an inheritance, but also has an inheritance that is left to them through a third-party special needs trust, they may actually have two special needs trusts. They may have a first-party special needs trust for money that comes to them in their name, and a third-party special needs trust that someone created through their own estate planning to leave them money. So the trustee really needs to look at what type of trust they're dealing with. If a person has both types of special needs trusts, they should use the money in the first-party special needs trust first, because there's a Medicaid payback. So deplete the assets in the first-party special needs trust for that disabled person's benefits. Once the money in that trust is gone, then they should use the money in the third-party special needs trust because there's no Medicaid payback requirement. In both type of trust, the attorney that is drafting the trust needs to give the trustee the discretion to determine what the most appropriate use of the trust benefit is. So even if it jeopardizes someone's benefits, even under a first-party special needs trust, the trustee may say, hey, Medicaid is not meeting the disabled person's needs adequately. I want to purchase insurance for them. So even though they may be eligible for Medicaid and would not qualify for Medicaid if obviously the trustee uses trust assets to purchase health insurance for them, private health insurance may be a better investment and may better address that person's needs than Medicaid. So the trustee has to be given discretion to use their best judgment based on the disabled person's age. So I realize that was a very quick explanation of special needs trusts, but if you have any questions, here is my contact information. And these are really complicated areas, and it's very hard to fit it into a discrete time frame. But again, I'm happy to answer any questions. If you want to email or call me, I'm happy to do that.